Say late, Mr. Mrityunjay Kumar.
May I please, Your Lordship?
Yes.
So order dated 19th of April 2019 is under challenge before Your Lordship. Just on a simple ground that Section 21 of Bihar Registration Act
उसको स्टॉप करें. We have given them a lot of opportunity. Yes.
Your Lordship, Section 21 of that Registration Act.
Registration Act.
Yesterday also I was placing before Your Lordship this point.
What point were you raising?
This only, Your Lordship.
Now let us see what is the order.
Yes, Your Lordship. Moreover, at the very outset, Your Lordships, I would be drawing Your Lordship's kind attention to the prayer made in the writ application. The prayer was, may I place that prayer before Your Lordships?
Yes, what do you say?
The prayer made in the writ application, Your Lordships. I would be drawing Your Lordship's kind attention to the prayer.
Yes.
Only one prayer was, there was only sole prayer of the writ petitioner was for registering an agreement to sale.
So that has, perhaps...
that has become infructuous now, that has been registered.
That has been registered.
Yes, that has been registered.
What is being prevented is the registration of the sale deed.
That is subsequent cause of action, and that has been challenged in separate writ application bearing CWJC
You
number
challenge that?
17001 of 2021. That is pending adjudication, Your Lordships. That order is
Yes,
under
Mr. Singh,
challenge.
what do you have to say to this?
Because that is pending.
Then?
That is pending where we have raised issues.
So this was against the agreement.
Yes.
Agreement.
So that
Now,
that
agreement
has
gets-
been registered.
So therefore, this latest patent, frankly speaking, becomes academic.
That is why. That is why. At the
Now, my
very
friend is
outset.
trying to raise some issues yesterday.
No,
He
no,
gave
no.
a hint
No,
of
no, no,
Section
certainly not.
21 and all
You see,
that.
at the very outset,
So
at the
therefore,
very
I have to
outset, I have
prepare
brought you.
myself with all the.
At the very outset, I have
No,
brought.
Mr. Singh, it would be a very interesting question of law.
It will be, my lord.
Now, here we can't adjudicate for the reason that the issue was only with respect to registering the agreement to sale that has been registered. So therefore no appeal. Now you need to, apart from that, where you want a direction to the registering authority to register the sale deed. Now there is a separate cause of action where you need to agitate whether the executive directions could take away the statutory power of a registering authority. Now in this case, there is a notification by the government holding that all such river beds of navigable rivers and river Ganges in addition would form part of the government land. They claim it as government land because it has not been surveyed and therefore declared as topo land. Now, you're right there in your counter affidavit when you say that the Bengal Alluvion and Diluvian Act, the government extracts rent from you with respect to any accretion of land with the recession of the river line.
Absolutely.
So such riverine beds also are treated to be part and parcel of the property which is contiguously held by the landowner. So therefore this decision of the Principal Secretary, which is an administrative decision holding such land to be a government land, requires further prop to stand. Now be that as it may, whether an executive instruction can do away with the statutory function of a registering authority.
No,
That's
not
one
only that.
question.
Not only that. Milos will kindly see Milos 21.
So therefore, Mr. Singh, you have to reserve and conserve your energy for agitating that case before the learned single
be doing
judge
that, Milos.
and in appeal, and otherwise also this is a separate cause of action that in many such districts, and where is the, अच्छा छपरा का है नहीं ये?
जी.
Therefore Ganges and therefore river.
Any river.
So would it apply? No, any river नहीं है. Any navigable river.
Right. Any river which
They
is
can't
navigable.
sort of make it so very comprehensive.
No,
It's
Miloj, this is-
beds of navigable river and river Ganges.
Miloj, where is it hurting the citizen?
It is.
Now this.
No, you're right.
principle-
You've said that very clearly in your counter.
Because
affidavit.
I'm taking it a little further. Why this attains a proportion of public interest? Because now this is being abused, this navigable river and all that is being abused by the officials to even declare lands which have been Gair Mazarua Malik for all the times to come, was settled to somebody, and now they are being declared as public land and actions are being taken.
That's right, Mr. Singh. We'll be
No, so therefore-
traveling beyond the mandate
No,
of this.
I know, because I'm saying
You
public
have-
interest,
you-
so therefore I'm
we-
going a little beyond.
We are conscious of this. We are happy also to note that you have taken pains to sort of take this
Because one
litigation to
who
that
has
level.
land will understand
But
the
had
pain.
you had this not been registered sale agreement,
Maloj.
perhaps we could have assumed the jurisdiction to
Yes,
decide. on.
yes, your lordship. Maloj, 22A, if your lordship will see of the Registration Act, Maloj, perhaps the authorities are also not aware of this. Maloj, this is the Registration Bihar Amendment Act. This is an
22.
amendment, 22A. And this is an amendment made by the Bihar government with respect to 22 of the Registration Act. This is a state amendment, 22A.
You are referring to 22A.
A. Now it says registration of document which is against the public policy. The state government may by notification in the official gazette declare that the registration of any document or class of documents is against the public policy. Notwithstanding anything contained in the act, the registration
And pursuant to that decision, that conclave of principal chief secretary, the chief secretary and others, have they come out with any notification?
No, not even an executive order. What has happened
Oral
is
instruction to collectors.
in the conclave, it was said that this is our lands are being taken away and this is an abuse. Therefore, stop it.
Highly assailable, Mr.
Absolutely.
Unfortunately, this is not the appeal in which we can
Because
refer
I
to
don't
that.
know if I'll be there tomorrow before your lordships. I really don't know, but
We don't know, but this is an issue which you must flag. It needs to be red flagged.
it has to be, my lords. It has to be.
The policy is, I mean, what I read from your counter affidavit, perhaps they have not raised it in their appeal. But from your counter affidavit, we found that the decision was taken so as to prevent any sale and purchase of the government land. Now, the very concept, the very decision making of holding such land to be government land, when they have been extracting rent from such landholders in whose land these pieces of land get क्या कहते हैं उसको, accretion. That's right. Anyway, this becomes.
Because if I may take just a minute of your lordship's time, because this is attaining such bad proportions that any executive authority
No, we
under
have
the
seen
statutory
this happening in so many districts.
Milods, I'll give you an example. Milods, the RERA authority here, Milods is restraining the registering authority from registering the flats. Now, which authority they do not have? They write letters to the registering authority, don't register flats because this builder is is doing something wrong under the RERA Act. Where is that authority? You can punish him under the RERA Act, yes. But how can you stop the registration of a property?
So please would you inform that whether this amendment to Bihar government has been challenged or not?
Sorry, Miller?
This amendment in insertion of section 22A
Milord.
has been challenged or not?
No, Milord.
It's not challenged.
No.
It means government has power to refuse.
ठीक है, किसी को इन्वेस्टिगेशन हुएंगे।
उसके तहत notification ये तो पावर पावर है ना, ये तो मॉडिफाई कर सकते हैं. So therefore, in pith and substance, the government of Bihar, the legislature of Bihar will have the powers to issue such kind of amendment. बहुत जगह है amendment, not only Bihar, there are many others. इसके तहत बिहार इसको चैलेंज करने के लिए तो वायरस ने चैलेंज करना, तो वायरस से चैलेंज करने के लिए नोटिफिकेशन कैन कम, है ना, ब्रॉडर सेंस में. ये वायरस नहीं उसका चैलेंज कर रहा है. दैट पावर द गवर्नमेंट हैज. The question is that pursuant to this power, this concession, if there is a notification, what is the rationale for holding it to be a government land? ये है. Public policy is a very wide term. So this, the government, the Bihar legislature has the power to make the law because it is in the concurrent jurisdiction, and not by pith and substance, but primarily such law can be made, such amendment can be made, and therefore you will find that in Himachal Pradesh and Rajasthan, in state of Orissa, there are different reasons. ये गलत नहीं है, इसकी वायरस चैलेंज करने के लिए इनको दूसरा डेट फ्री करना है. This offends nobody. Against public policy they can always do. उसके तहत जो नोटिफिकेशन रहता है वो नहीं होता. All right.
Very well.
देखिए,
There is a limitation of 200 odd days, Manoj, so.
That has been duly explained, Your Lordship.
all right, I will say that. Now, 664 days, Corona time, Supreme Court judgment,
Ji.
therefore that's a reasonable ground. For the reasons stated, IA number so and so, for the reasons stated in the application, the delay in preferring the appeal is condoned, the application stands allowed. Stop. Mr. Alok Ranjan, learned advocate for the state/appellant, submits that the order impugned was passed by the learned single judge in a petition which had sought relief for a direction to the registering authority to register the agreement to sale. First up, notwithstanding notwithstanding the instruction of the district magistrate of each of the concerned district to the registering officer not to register any document relating to sale or purchase of topo/unsurveyed land, the agreement to sale between the respondents and the third party has now been registered. First off, in that event, this appeal has become infructuous. First off, the land counsel for the appellant as also the respondent have informed this court that with respect to such direction for registration of the sale deed, a separate writ petition is pending adjudication. Stop. The respondents would be well advised to contest the aforesaid writ petition. Stop. This appeal, therefore, has become infructuous, dismissed as having become infructuous.
Obliged, Manoj, grateful.
Your Lordship disposed of it. It may be humbly prayed